Well, since we're recording this, let's go ahead and get started. And anybody who comes in later can catch this. So I've got the makings of an exam here. I don't have it ready to launch as soon as this is over. That's probably a good thing. But it'll be open for, a few days here. But this is probably as succinct as it gets when it comes to an exam review. So what I'll do here is basically lay out part of what you'll get. No, I'll lay out all of what you'll get. You'll just get part of this, all right? So I'm not going to say everything here is going to be on the exam, but everything you get on the exam will probably be in here, all right? So it's a lot of stuff. Let's start off with chapter 17. And of course, the exam is going to cover chapter 17, 18, 19, 24, 25, 26, 27, and 28. Not all parts of some of those chapters. For example, the cultural resources, I'm only going to cover the part about NAGPRA and the ancient one. There we go. Heath is here. That's good. So 17, 18, 19, 24, 25, 26, 27, and 28. Hello, Heath. We'll go ahead and we're just now getting started. So I'm going to begin with chapter 17. And what I'd like for you to do is go ahead and everybody go ahead and unmute yourself unless you're, somebody's mowing the lawn in the background, and chime in here. I won't be giving you the answers, but if you give the answers, then this will be recorded and might be helpful. Okay, so let's start off with this one. This would be a short answer question. When I say 5 points, that's probably a short answer question. If I say 3 points, it's a short answer question. If I say 2 points, then it's a multiple choice or true false question usually. Okay, so this is a 5-pointer. It's a short essay short essay question. Basically it's one of my list 5 things. So list the 5 mandatory PL 280 states. And I might say something like list the original 5 mandatory PL 280 states, which would exclude Alaska. Okay. Anybody want to try that?
California was one.
That's one. California. Well, you can look that up.
Was Oregon or Washington one?
Oregon. Let's see here. I got notes.
Oregon, Wisconsin, Minnesota, Nebraska, California.
You got it. That's it. So Wisconsin, Minnesota, Nebraska, Oregon, California. Geographical order, sort of, east to west. Here we have another 5-pointer. Explain what PL 280's intentions were and whether these were accomplished, or something like that. How well did it meet its goals? I think that's all I'm going to say about that. Another one. This was kind of a complex one. how did the fact that California was a PL 280 state affect the emergence of legalized casino gambling in Indian country across the United States? That's certainly worth 5 points. Anybody want to talk about that? So California was a PL 280 state. What Supreme Court case launched what Supreme Court case led to the congressional legislation, the traditional congressional legislative knee jerk to yeah, okay, so Cabazon, California versus Cabazon Mission, California versus Cabazon band of Mission Indians. I think it's incorrect in your text. Anyway, it would say Cabazon. That was a 1987 Supreme Court case. Who won the case, California or the Cabazon band? It's actually Cabazon and Morono, I think.
I think it was Cabazon.
Yeah, the Indians won that one. And so we know California was a PL 280 state. You suppose the fact that it was a PL 280 state led it to do what it did to bring on the lawsuit? Raise my chair up. Yeah, I think certainly it did. Because California was a PL 280 state, kind of like Minnesota in another case, in the case where the state attempted to levy a personal property tax on the guy with the trailer on Indian land. Okay, and it was found that they couldn't do that. State couldn't do that. Similarly, in California attempted to regulate, although it didn't say that at the time, it attempted to basically put the brakes on what was going on in Indian country with high stakes bingo. High stakes bingo is what everybody had before the Indian Gaming Regulatory Act was passed. So 1987, you get Cabazon. California loses largely because California presumed it had jurisdiction over Indian country. But why did California lose? That's another question. Why did the Supreme Court rule against California in Cabazon versus in California versus Cabazon? Okay, so kind of 2 questions there. Why did the Supreme Court rule against California, or why did California lose?
Well, they thought, I think it was the court said that just because it's criminal, it doesn't carry over to civil.
Something like that. Something like that. This is in the PL 280 chapter, so there wasn't a lot of distinction made between criminal jurisdiction and civil jurisdiction, but it leads into that discussion. But you're on the right track, because that's the area where the Supreme Court made a decision about what California was doing. Okay, does that help?
Wasn't it because California already had like their horse racing and they were already publicizing all that stuff, and they thought the Indian gaming would divert away from their state lottery?
Right. So California argued in this case that it was, since it was a PL 280 state, we know what is the reason PL 280 even existed. It was created to allow states to extend criminal jurisdiction into Indian country, into certain reservations of Indian country. even the mandatory states had a couple of exceptions, right? Oregon and Minnesota, or Oregon and Wisconsin both had 2 exceptional reservations where PL 280 did not apply because the tribes had law enforcement agencies that were functional within those reservations. Therefore, the government, the federal government didn't see any reason to allow the states to, inroads to jurisdiction. So it was only the states that had relatively small tribes that didn't have a lot of resources to support their own law enforcement agencies, right? And in California, you've got a lot of tribes, but they're all pretty small and not very wealthy. So California made the point, or argued, that it was operating within its purview to enforce criminal jurisdiction in Indian country by not allowing the tribes to do this. Now that was what the lawyers came up with when it was pretty clear that there was a problem. And of course, the argument was that California made the argument that if the tribes begin to have casino gambling, then this will bring in organized crime. They said the same thing in Oklahoma. They said the same thing in every other state before this happened. Casino gambling always brings in the mob. But what the Supreme Court said was, wait a minute, California, don't you have a lottery? Don't you advertise a lottery? Don't you have parimutuel racing, horse racing? Don't you allow bingo for fundraising? Don't you allow various clubs to do sort of lower stakes bingo and things like this? Basically, what the Supreme Court said was, while the state claims a criminal jurisdiction, what it's in fact doing is acting as a regulator, because it already has gambling. Therefore, it's simply regulating, and because it's basically because this is regulatory rather than criminal, it's civil jurisdiction rather than criminal jurisdiction. And that civil regulatory jurisdiction was merely isolating the tribes and discriminating against the tribes for gambling. I think what Sarah said, that's a good point, that California is not only regulating them, but California is not a disinterested party. California has a dog in the fight. They don't want Indian casinos because then the state lottery may lose business. So the Supreme Court came down on California, who lost. Now let's go back to the other question. Explain how PL 280's intentions. Excuse me, not that one. How did the fact that California was PTOA state affect the emergence of legalized casino gambling across the United States? Well, my point there in asking that question is, think about, okay, the PL 280 states are the ones that you would think have the most authority in Indian country, right? But not when it comes to civil regulatory jurisdiction. And that's pretty much what all casino gambling is going to be. So in response to the Indians winning the lawsuit, Congress immediately comes up with a legislative fix, right? When was it? The case was over in '87, and the IGRA, the Indian Gaming Regulatory Act, was 1988, right? Was it 1988 or was it 1990? No, good stuff on this. All right. So PL 280. Okay. Anyway, cabazon is mentioned prominently in 2 chapters that you're covering on your exam. So, see if I can find it. So PL 280 chapter. Mixing them up. Here it is on 367. So it's tail end of that chapter. What was it I was asking? I can't remember. Okay, well, in terms of PL 280, it turns out, okay, and you probably know what everybody's opinion is pretty much on PL 280. But since California was a PL 280 state, the law came about to regulate Indian gaming nationwide. Because if tribes were not within a PL 280 state, which most weren't, Oklahoma tribes weren't in the PL 280 state, then that meant that states had even less influence over tribes. That make sense? All right. So if it was clear that in cabazon that even a PL 280 state would lose a case trying to regulate Indian gaming, then Congress had to do something, right? And Congress is usually doing something because of some interest to their, to congressional constituents, right? And Indian tribes are not congressional, are not the constituents to Congress. The Indian tribes they're regulated by Congress. They're, everything about their existence is pretty much determined by what Congress does, but they really don't have any representation in Congress. It's the people who have the representation. So that's why we get the IGRA. And of course, your chapter on IGRA is what? I'm kind of jumping over there accidentally. Chapter 24. So we'll go ahead and talk about it since we're there. So you might get a question like, okay, why did California lose this case? And the answer would be something like, well, California attempted to call this a prohibitive criminal jurisdiction when in fact it was acting as a civil regulatory agency or state. So the Indian Gaming Regulatory Act comes about following this in, oh, there's no date on there, is there? It's got to be, it's 1988, isn't it? Or is it 1990?
It's 88.
Is it 88? Okay, thanks. All right. Indian Gaming Regulatory Act, 1988. And we'll come back. We'll come back to this. I've got more questions for you about IGRA, IGRA. All right, back to PL 280. What type of law did PL 280 affect? What division of law?
Civil.
Well, that's one of the possibilities. but it's not the correct. It's criminal. PL280 pretty much extended over criminal jurisdiction only. Right? And criminal jurisdiction is the one that, the federal government's been, the states and the federal government have been arguing about criminal jurisdiction all the way back to the 19th century, even the 18th century for that matter. Since I'm here in my junky living room, this is my laundry. I was going to say, okay, here's a good example of that. All right, this is a really good book on the extension of federal and state court jurisdiction into Indian territory, and between the treaties of 1866 and statehood. But that particular writer goes into this subject quite a bit, and so you have Talton versus Mays and all those cases. So criminal jurisdiction's always been an issue in Indian country. Civil jurisdiction only really comes about when we're talking about economic development, and also once really civil jurisdiction really only comes into play after allotment, when there's real estate involved, right? And also you could probably even say after the Indian Reorganization Act, after the Indian New Deal, because that's when tribes actually started functioning as corporations, as governments, corporate entities, I should say. And really the self-determination era, beginning in around 1970 or so, brings about the ability for tribes to to kind of go their own way and do their own thing and take care of business themselves. Any questions over all this stuff? Oh, here's another thing you might want to consider. On that question about why did California, lose that case? The United States, of course, was supporting tribes during the 1980s, during the Reagan administration mainly. The federal government was encouraging tribes to branch out and try things like gaming in order to fund their own operations, their own tribal operations, so that they could become more self-sufficient, so that the federal government was transferring funds for things like ambulance services and eventually health. Cherokee Nation is a good example of this, and the Chickasaw Nation, under Wilma Mankiller, the Cherokee Nation began to, and Wilma Mankiller was she was a charismatic person, and she wound up getting the BIA to turn over a lot of things like ambulance services initially, and then they started building health clinics and dental clinics, and it helped at that time. This is in the mid 80s, which I remember really well. It helped at the time that the head of, hey, Shayla's here, good, we got 100%. It helped at the time, back in the 80s, that the head, hey, Shayla, it's good to see you. Can you hear me? Oh, she's connecting. All right, can you hear me now, Shayla? Go ahead and unmute yourself so you can interact. All right, good to see you. You're still muted, I think. Anyway, it helped in the mid 80s to late 80s when Wilma Mankiller was chief of the Cherokee Nation, that the head of the Bureau of Indian Affairs was a guy by the name of Ross Swimmer, who was also a Cherokee. he was actually a former Cherokee chief as well. So the Cherokees, were able to kind of get this going for their own tribe. Anyway, during the 80s, with deregulation and everything, it was the federal government's prerogative, or the federal government's encouragement of the tribes to take on handling things like social services themselves. And eventually they would take over housing services and all kinds of stuff. Unfortunately, housing is not really covered in this book. That's another facet of Indian country. Okay, so anyway, that was just one thing I wanted you to think about. We're still on chapter 17, so if you just arrived, you haven't missed much. And this is going to be recorded so you can catch that, what you did miss, or later on. Why were certain reservations exempt from PL 280 in the mandatory states? That would be like a 2-point question. Why were certain reservations, was the Warm Springs Reservation in Oregon and the one in Wisconsin, I can't remember the name of it. Anyway, why were those exceptions there?
Did they already have a big enough criminal justice system already set up in place, or?
They're already functioning. They weren't deficient in criminal, in having a judiciary and an agency to do law enforcement. So, in other words, the federal government didn't just blanket everybody. It said, well, here are some exceptions to the rule. We don't need to have states involving themselves in that, in their area, their res. What was the first reservation? This is kind of a tricky question, but it's a good one. What was the first reservation to have state criminal jurisdiction extended over it by Congress? And remember, this is chapter 17, PL 280. Look at I think it's the very first part of it. Yeah. Page 354. The first little piece of legislation that's boxed in the little gray box. Page 354, the Devil's Lake Jurisdiction Act. What was the date on that?
46.
46, yeah, same year as the Indian Claims Commission Act, right? So this is another reason why I always say that the termination era really started in kind of 1946, right after World War II. It didn't start in 1953 necessarily. That's what your textbook author says. But anyway, 46. So in that, basically what happened there was it was legislation for an individual reservation in North Dakota, the Devil's Lake Reservation, and so Congress, did this. It allowed North Dakota to extend criminal jurisdiction over the res, and I guess eventually everybody thought, well, that's a good idea for all of these tribes that are having issues with law enforcement. So let's just do it for let's try to hit all those states that are having the same problem. So you get these mandatory states in 1953 with PL 280. All right, 7 years later. So I would guess you could say Devil's Lake Jurisdiction Act is kind of the prototype for PL 280. Okay, well, that is about it for chapter 17. Don't have any questions on that one? Okay, chapter 18, criminal jurisdiction, is pretty thick. It's that and civil jurisdiction is even thicker. But criminal jurisdiction, we start off with a really important case, really significant case. And in fact, I think I think your textbook author says the most significant case regarding sovereignty, something like that. You have to agree with him. The case is called Oliphant, kind of like elephant, but Oliphant versus Suquamish. I always see that and I say Sasquatch, right? Oliphant versus Suquamish Indian tribe in 1978. Really significant Supreme Court case, right? So if you're not there in your tech, go and turn to page or chapter 18 on page 373, and Oliphant versus Suquamish Indian tribe is a United States Supreme Court case, ruled on in 1978. And for all cases like this, I want you to know, I want you to be able to identify the background. I mean, if you got like a multiple choice question with 5 different cases on it, I'd want you to be able to pick out that case with a short description of either the context, what was happening, like, for example, maybe an Indian tribe, maybe the Crow tribe extended its hunting and fishing regulations over non-Indian feed land and within the reservation, something like that. So that's when you would identify, the case. In this case, so be able to know a little bit about the context of the case for those multiple choice questions, and even more important, be able to identify the significant finding within that case. And sometimes there's more than one significant finding in really important cases like Oliphant. So what were those big findings in Oliphant? What did it do? One of the things that I pulled out of this chapter that I had never even heard of was something called the Western Territory Bill, and I've got to look into that. That's too interesting. Never heard of that. And that's why I have this book out, because it's not even mentioned in this book either, strangely enough. The Western Territory Bill of what? Sometime, it must have been in 1834 or something like that. Yeah, 1834. It failed. So what did Oliphant do?
Tribes don't have the authority to prosecute non-native individuals.
Oliphant totally ends the possibility of tribes having jurisdiction over non-Indians committing crimes in Indian country. That would later get an exception. But at the time in 1978, that was pretty much what happened. Tribes were kind of, wondering, and, attorneys were wondering, well, if tribes are having their own law enforcement agencies, how do you deal with non-members, non-tribal members? I should make a distinction, right? Because later on we'll see a distinction between non-Indians in the government sense and non-member Indians, right? Non-tribal member Indians. So it's kind of an interesting story with criminal jurisdiction. So yeah, that's it. The big one is that it pretty much started the it puts some inertia behind this idea that non-Indians are just not subject to tribal jurisdiction. So what would be the sort of theoretical, what would be the constitutional or theoretical or judiciary reasoning for that? I mean, can John Marshall somehow be blamed for this? Yeah, John Marshall can definitely be blamed for this. How? Clarence Thomas and Antonin Scalia and Stephen Roberts, is that his first name? All of those conservative those conservative justices would find even more significance in this idea that tribes just don't have jurisdiction over non-Indians. Okay. More and more. So anyway, I think anybody want to take a shot at it? It has to do with the status. It has to do with the definition of native peoples or tribes, not native peoples, but tribes by John Marshall, Chief Justice John Marshall, and Cherokee Nation versus Georgia.
Is that the domestic dependent nations?
That's right. That's it. It's the dependent status. Okay. Marshall defined Indian tribes, nations, as dependent nations. They're domestic, meaning they're they're located within the exterior boundaries of the United States. They're not foreign, they're domestic. But they are also nations, but they are dependent nations, dependent because the United States has enveloped them, dependent on the federal government. And this is, it's not so much a meaning of, economics in that sense. A lot of people, initially I would think, okay, that means they're needy. That's not what it means. It means that they are, their dependent status affects their ability to rule. They can only rule over their own people. So territory, Indian country started out, before 1787 with the Northwest Ordinance and stuff before that. Indian country was territorially defined, right? If a non-Indian, if an American, or Virginian or Tennessean or something crossed into Indian country, then up till the Constitution, the law was, you're on your own, buddy. The United States is not going to protect you. If you get in trouble with Indian tribes, they have all the right to deal with you. Okay, and so that gradually changes until we see things like the federal government extending its sovereignty over Indian tribes with the Major Crimes Act in 1885. So now you've got the reverse going on. Now you've got the Indian tribes trying to, not just trying to enforce the law within their own boundaries, within their own territory, but it's the federal government now says, well, no, you can't enforce your laws over non-Indians. They are subject to the states. They're subject to the federal government, not to you. So this dependent status is taken as the basis for criminal jurisdiction and later civil jurisdiction. Oliphant is the first case, as Justice Ruth Bader Ginsburg would say, the sort of path marking case for jurisdiction, Oliphant. Dependency is what it's all about. They're using that word to draw their conclusions about what tribes can do. Now, the exception to that is, what's the exception to Oliphant today? The only real exception. And it makes sense that it's an exception, I think. There are a lot of ways that non-Indian people can cause trouble in Indian country. But, you know, I have a bunch of law enforcement people in my family, and I can tell you that the last type of crime that they ever want to have to deal with is domestic violence. Not only is it hard to deal with, you know, psychologically or emotionally, but it's also very dangerous. People do crazy things when they're in love or out of love or whatever. So the example here is the exception to Oliphant is the reauthorization of the Violence Against Women Act, the 1994 Violence Against Women Act. And in 2013, that law was reauthorized. And when it was reauthorized, they wrote in an exception for tribal governments and criminal law. That exception, what it did was it extended, and only in cases of domestic violence, it extended tribal jurisdiction, tribal criminal jurisdiction over non-Indians who were implicated in domestic issues, domestic violence issues. That makes sense, doesn't it? Because you're going to be dealing with typically non-Indians living with Indian people on Indian land, okay, in a reservation or whatever allotment. So that's the exception. Let's see, how did the Duro fix to the 1968 Indian Civil Rights Act create a problem? What is the Duro fix, first of all? And how did it create a problem for justifying the inherent sovereignty of tribes as found in Wheeler? And what was Wheeler? All of y'all are muted. I can't hear you. I can't hear you answering the questions. I know you're doing that.
I'm just typing really loud.
I can see the ladies here on my screen and myself, and I know that they're not trying. Well, they're not uttering the answers, but all you guys, you don't have your video cameras on, so I don't even know if you're really there. So, you know, believe me, I've been in enough faculty meetings on Zoom now that I know how to get away with things. You know, one thing you can do when you're in a Zoom meeting, you know, like you log in, and then if you have a Mac or something, you do a screenshot of yourself, and then you go to Zoom and upload that as your profile, and just turn your profile on. And some people will think you're just listening, and in fact, you're making a cheeseburger, right? So anyway, it's fun. Great things you learn with Zoom. Oh God, I just recorded that with Zoom. All right, so anyway, what was the Duro fix? The Duro fix was an adjustment to the Indian Civil Rights Act, and that was it attempted to patch a hole in the Indian Civil Rights Act. And by doing so, what it did was it said, okay, the little excerpt is on page 387 of your text, okay? And it says, for the purposes of this subchapter, the term blah, blah, blah. Number 2, powers of self-government means and includes the inherent power of Indian tribes, hereby recognized and affirmed to exercise criminal jurisdiction over all Indians. That term, all Indians, okay? And we know that Indians is a legal term in federal government, right? So what did that do? How did the Duro fix screw things up? And by the way, the Duro fix was a reaction also to it came out of the 1990 case, Duro versus Raina, and that ruled that the tribal courts can only prosecute tribal members while other tribes are exempt as non-Indians. Okay, so the way this by 1990, and I remember this, it was odd. So say for example you're speeding, you're speeding through an Indian reservation, and the tribal police clocks you going 85 and a 60, and so you're gonna get a speeding ticket, but only if you're a tribal member. All right. So now if you're only a tribal member, okay, but what if you were say a Choctaw in the Chickasaw Nation? All right. So a Choctaw speeder in the Chickasaw Nation wouldn't be covered under Duro versus Raina, but then Congress comes in and they do this Duro fix, and they change it to all Indians. So then the Choctaw speeding through the Chickasaw Nation could get the ticket too, but not the white guy, because he's not covered by tribal jurisdiction. All Indians are. So this was just goofy. Y'all see the difference here between non-Indian and non-tribal member Indian? Okay, so what legal or what case then challenged that problem of the Duro fix? The Duro fix is something that needed to be fixed.
U.S. versus Laura.
Yes, U.S. versus Laura. And what was the deal there? What happened? Who was Laura? Lara, right? What was the context of that case?
I think it was the prosecution of outside tribal members, I think.
Yeah. Had to do with double jeopardy. Two prosecutions were brought by two different sovereigns. The second federal prosecution does not violate double. Anyway, well, to read Justice Breyer's summary, we must decide. So this is the case. He's leading into the case in his opinion. We must decide whether Congress has the constitutional power to relax restrictions that the political branches have over time placed on the exercise of a tribe's inherent legal authority. We conclude that Congress does possess this power. So this is Stephen Breyer, and U.S. versus Lara is one of those cases that probably would not have been found in favor of the tribes had it not been for the Indian canons of construction. All right. So what that court case did was it luckily found in favor of the tribes to what? And he listed 6 different sort of aspects that to support the concurring opinion. One was the concurring opinion being that we believe that Congress intended, basically this is saying that Congress has pretty much every possible authority to change the rules for Indian tribes. And see, the issue that was the real serious issue that was popping up here was Congress sort of did this Duro fix, right? And by doing that, they were essentially changing the sort of in a deep way, they were kind of changing the origins of tribal authority. And Congress could do that. And what that threatened was Wheeler. Remember Wheeler? What's the whole name of that case? You have to go back to the last exam. The stuff, I think it was, it's Constitution. So if you go back to the chapter on tribes and the Constitution, which is way back there, and you see United States versus Wheeler. Remember what United States versus Wheeler dealt with? It was that Navajo case where and basically the question came down to what's the origin of the authority, the origin of sovereignty, really. What's the origin of sovereignty? And the question was the tribe, did the tribe sovereignty emanate from some inherent, distant, ancient source of being a nation? Or did the tribe's sovereignty basically, was that just functioning as an arm of the federal government? Remember, it was a double jeopardy case. And the guy was saying, well, basically the tribe's part of the federal government. So the court said no. Wheeler was really, really significant, and that the courts ruled that the source of tribal sovereignty is inherent. Really important word, inherent sovereignty. It's just there. It's there from time immemorial. It's not something that the federal government creates. All right. So in United States versus Lara, the concurring opinion held that idea that tribal sovereignty is inherent, yet Congress can do anything it pleases with regard to tribal sovereignty. All right. And that's when one of my very favorite current justices of the Supreme Court brought up a really big question. And that would be Justice Clarence Thomas. The guy's a very good thinker. But he in this dissenting opinion made a really big point, and that was that you've got an inherent federal Indian law is based in a contradiction. That's what he says. Federal Indian law is based in a contradiction. What's that contradiction?
That they're sovereign, but yet they still answer to Congress.
I'm sorry, I talked all over you. Say that again.
That tribes are sovereign, but that they still are at the mercy of Congress.
Yeah, that's it. So how's that a contradiction?
Doesn't make any sense.
What's sovereignty? Yeah, what is sovereignty? I was listening to I don't know what it was, a newscast, or maybe it was a movie. Maybe it was a movie. But, you know, someone said sovereign. Oh, it wasn't. No, it was, you know what it was? It was Chris Rock. And he was talking about, it was on that show, one of those episodes of Fargo. Have y'all watched that? Fargo. If you like, you know, in the fourth season of Fargo, they practically kill everybody in Kansas City. But, you know, it's make believe. But he was talking about sovereignty, and you know, what is sovereignty? And it's power. It demands respect, right? And it reminded me of this. So maybe I'll find that clip somewhere. But yeah, this is Clarence Thomas. He just kind of lays it out on the line and said, hey, by the way, you know, next time we have to rule on one of these Indian law issues, we might want to consider the fact that there's an inherent, you know, there's a contradiction in this whole game of federal Indian law. All right. Thanks for your input there. Let's move on. Civil jurisdiction. Now, in this chapter, be able to recognize all 5 cases. If I gave you a cryptic description of it, what you're going to be looking for is Montana, 1981. It's Montana versus United States, 1981. Next one is Strait versus A1 Contractors, 1997. It's a short one. Nevada versus Hicks, a very important case, 2001. Important to Indian country. All right. Next one is Plains Commerce Bank versus Long, and that's 2008. And finally, the Dollar General Corporation Incorporated versus Mississippi Band of Choctaw Indians. Okay, so be able to recognize the contexts and the significance or significance of each of those cases. Okay, so why don't we just go through each one of those quickly, and then I'll ask you some other questions about this chapter. What did Montana bring us?
Montana test?
It was the Montana test. Yeah. What is the Montana test about? Yeah, it's extremely important. Now, the Montana test is kind of a segue between Oliphant and criminal jurisdiction and civil jurisdiction. So Montana is kind of the corollary of Oliphant. It's sort of the civil jurisdiction corollary of Oliphant. Okay. You remember the context of the Montana case? Mentioned it earlier.
That was the one with the Crow exerting their hunting rights or laws.
Right. And involved a guy who was fishing, right? He was fishing in the river, and the question was, okay, well, is the river Indian country or is it state? And so lots of questions about territory and that sort of thing. But they went back to Oliphant, right, in determination of whether or not the tribe had jurisdiction. And like Oliphant, they said what? This is a non-Indian fishing and this is a non-Indian, winds up fishing in the riverbed that's owned by the state, yet within the boundaries of the reservation. So who has jurisdiction, the tribe or the state? Even though it's within the reservation, the state. Okay, so the tribes lost that one. In the civil jurisdiction chapter, the tribes lose almost all of them. Okay, so following Oliphant, you have this Montana test, and the Montana test has 3 parts, which is always convenient because I'm looking for 3-part questions on exams. So if you were to be asked, what are the what's the basic presumption in the Montana test, and then what are the 2 pardon me, what are the 2 exceptions to the Montana test? That would be an essay question, probably a 5-point essay question. And by essay, I mean a paragraph. So define the Montana test, including its basic presumption and its 2 exceptions. What's the Montana test for? COVID? No. The Montana test is for what? Okay, well, what you can find all this, you can find this within the case itself at the bottom of page 398, that paragraph within the gray box on page 398. The original presumption is that the inherent sovereign powers of an Indian tribe do not extend to the activities of non-members of the tribe. The inherent sovereign powers, okay, from inherent sovereignty of an Indian tribe do not extend to the activities of non-members of the tribe. That's the original presumption or assumption. I don't know what you call it. I guess the author thinks it's presumptive, so or presumptuous, so it's a presumption. Anyway, the exception number one, when the tribe would have civil jurisdiction over a non-member in Indian country, would be if that non-member has entered a consensual relationship with the tribe or its members through commercial dealing, contracts, leases, or other arrangements. Okay. Now, when I see the word consensual, I always think about what he said, what she said, that sort of thing. Maybe that's my problem, but anyway, that's what I always think of. And so, like, if like a non-Indian's married to a tribal citizen, would that be a consensual relationship? The answer is no. That's not what they mean. Okay, so this is legalese confusing Brad. But anyway, I don't, consensual, what that really means is business. Okay, so commercial dealing, contracts, leases, and other financial arrangements, that sort of thing. That's what consensual arrangements mean. And so exception number one, the tribe will have jurisdiction over non-Indians acting in Indian country as long as there's a contract showing that the non-Indian agreed in advance to being subjected to tribal jurisdiction. That's all that really means. So I'm only going to get a ticket speeding through the Chickasaw Nation if I've consented to, being ticketed. Well, not really, but it's kind of the same idea. If you're going to do business in Indian country, more than likely you're going to be signing a contract. The tribe's going to be signing a what do we call it, a waiver of sovereign immunity. They're going to be waiving their sovereign immunity, and you're going to be consenting to their jurisdiction most of the time. So that's exception number one. Exception number 2 is even weirder, I think. Harder to maybe conceptualize, but a tribe may also retain inherent sovereign power or inherent power to exercise civil authority over the conduct of non-Indians on fee lands within its reservations, within its reservation, when that conduct, you can underline this part, when that conduct threatens or has some direct effect on the political integrity, the economic security, or the health or welfare of the tribe. Now, with the last case in this chapter, that'll become apparent. But what that is saying, exception number 2, is since the tribe is concerned with the well-being of its members, it's certainly concerned about the well-being of its people, then it's to be assumed that the tribe would definitely have a stake in the safety and security of its people. So there doesn't need to be a contract there. It's just inherent that, government, regardless of what, if it's the state of Oklahoma, if it's the city of Stillwater, or, or the Ponca tribe, the government of those entities are assumed to have responsibility for some sort of protection. They're supposed to be looking out for its citizens, period. I don't know about the city of Stillwater, but whatever. State of Oklahoma for sure, the federal government definitely. Okay, so idea here is that you have 2 exceptions. One is based on a contractual relationship. Number 2 is the tribe's going to have an inherent interest in the safety and well-being of its people. So if there's some sort of threat to that, definitely the tribe has jurisdiction. Okay, Montana test. So let's put the Montana test to work. Let's go ahead and put it to work. So in Strait versus A1 contractors was its pertinence to this chapter is basically how Justice Ruth Bader Ginsburg defined consensual relations, or actually the way that she, and this is like one of the more liberal justices on the Supreme Court. Strangely, curiously, interestingly, whatever, she rules kind of like a conservative justice, I think. She cites, it's kind of a technical type of case, because you're dealing with a stretch of road and whether or not there's Indian country or not. This is the one where the guy is where there was a car wreck, right? And it involved a tort claim against a driver. So when I read this initially, I thought, okay, well, the lady that was hurt or was injured in this wreck, she's married. Okay, she's married to a tribal member, and she has 4 kids who are tribal members, but she is considered to be a non-tribal member. So she couldn't bring it. the tribe didn't have jurisdiction. Am I reading that, remembering that right? I'm not really looking at my notes. But basically, this is one of the cases that kind of shaped what this consensual relationship meant. I don't worry too much about it. Nevada versus Hicks. Now, be sure you know about Nevada versus Hicks. And let's start off with the context of that. Somebody tell me the context of Nevada versus Hicks. (2001). This is the one that had to do with the tribal member being accused by the state of Nevada, the Fish and Game Department, of poaching, and so they were trying to find evidence of California bighorn sheep. Is that what it was? And so they searched it. They warrant the searches. Actually, the tribe and the state didn't search his house. They didn't find anything. Like a year later, they came back again and then somehow damaged his property. And they didn't find anything. So he's suing. So the question is, this gentleman, this tribal member, is attempting to seek damages for property in Indian country, his personal property within Indian country, trust property, damages caused by a state official. So the question is, can a state official be tried within a tribal court for activity that he, for acting poorly on tribal property? Anybody have a better way of describing that? Is that what happened? So the question of jurisdiction was, can this guy sue the individual in tribal court? And the answer was no, he's not covered. State official's not covered. So tribes lost that one too. And the last one that the tribes lose here is called Plains Commerce Bank versus Long. And this is it's a little more difficult to understand than the other ones. Anybody want to describe it? Plains Commerce Bank. This is one that's often cited a lot, and it was pretty significant because it had to do with fee land. What are the three? Here's another question for you, a three-pointer. List the three status forms of land within a reservation which produce variations in tribal civil jurisdiction. List the three status forms of land, that is basically the type of title, within reservations that produce variations in civil jurisdiction. That's a question. That's a test question. At least it's a preliminary test question. What would you answer that with? I mean, there are a lot of different types of, technically a lot of different types of land, more than three, within Indian country, right? There's tribal land, there's tribal fee land, there's individual fee land, there's individual trust land, there's federal land, there's state land within Indian reservations. So there could be municipalities. So we got a lot of different variations, but what are the three basic ones that lead to variations in jurisdiction, civil jurisdiction? It has to do with the type of title, and it has to do with ownership. See if I can find it for you. Yeah. Go to the third paragraph on page 396. Bottom paragraph, page 396. And it's referring to checkerboarding, which you know what checkerboarding is, right? But what are the three colors on the checkerboard of this type of stuff? And three different types of land are trust land.
Trust, Indian fee, and non-Indian fee.
You got it. So trust land is trust land is trust land, whether it's owned by the tribe or an individual allotment or tribal land. If it's trust land, it's all the same. But then you have Indian fee land. So you have fee land owned by a tribal member or fee land owned by the tribe. Okay. And then you have fee land owned by non-Indians. And of course, fee land owned by non-Indians is the least, that's the one that causes all the trouble. Fee land owned by non-Indians. And when you have non-Indian actors on fee land within reservations, they're almost completely out of the jurisdiction of a tribe. And so what Plains Commerce Bank was dealing with, this was interesting part of this case, is that you had tribal members with fee land within a reservation, and they put this fee land up for collateral. They were losing money apparently in their ranch. They put this fee land up for collateral, and then they apparently defaulted on their loan or something, and the bank foreclosed on that. The bank held the property with a lien, so the bank basically sold it, and sold it for more than what the loan was for. So the bank made money, and that's usually the case when somebody's in trouble like that. But whether it's a car or whatever. So the bank made money, and that, of course, the tort claim was that what the tribal members did was they said, okay, well, can the tribe stop this or somehow, can we get the bank to can we have this tort claim heard in the tribal court? And what was the answer? It was kind of frivolous. I mean, if you read through it, it's really kind of cheesy what these people were doing. But essentially they were saying, okay, we've got this fee land owned by non-members, owned by the bank, and so what the plaintiffs were trying to do. This was on appeal, so it was the bank was appealing this. So in the Supreme Court, the original plaintiffs, Long, were they were saying that this needs to be within the realm of tribal jurisdiction, and Supreme Court did not go for that. So Stephen Breyer, I think it was. No, it was John Roberts. Justice John Roberts wrote a scathing opinion. I thought it was fairly scathing. And what did he say? What was the point of that opinion? It wasn't anything that was really groundbreaking, but anyway, in Plains Commerce Bank, what the point was that once land passes into fee title, it's outside of the jurisdiction of the tribe. Fee land is pretty much gone from tribal jurisdiction, even if it's owned by tribal members. So that would be tribal, or tribally owned fee land. That doesn't even have, that's not jurisdiction for the tribal courts, or at least in civil cases. Any questions so far? All right, finally, Dollar General. I've got one about a few hundred yards away from me here. Dollar General Corporation versus Mississippi Band of Choctaw Indians, and this is a circuit court. This was finished at the Circuit Court of Appeals. So originally it was Mississippi Band of Choctaw Indians against Dollar General Corporation. Right? Who won that one? So basically the district court found in favor of the Choctaws, and so that it went to appeal by Dollar General. That's why Dollar General is the petitioner, not the respondent. So I alluded to this when we first started talking about Chapter 19. It's the only case in this chapter that the tribes won. The significance of this case is that it's the very first federal case in which a tribe was found to have civil jurisdiction over non-members. Okay, basically that's it. They were non-members, but on tribal land within a reservation. Okay, so non-Indians acting badly in Indian country, as long as they're in trust, on trust land within a reservation, the tribe might have jurisdiction because of the Montana rule. And that's so how did the Montana rule work for this one? That would be a good question. How did the Montana rule work out in Dollar General Corporation versus Mississippi Band of Choctaw? Well, okay, if the tribe won, then there was an exception, right? Which exception?
Probably the second one.
The second one.
See cost harm.
Yeah, okay, we didn't talk about the context. The context of this case, remember, was there was this Dollar General, and I was surprised to learn that the Dollar General is actually built on tribal land. So maybe the tribe leased the building, probably what it went. The tribe probably leased the building to Dollar General, who had a store on the reservation, and so then the tribe started this youth internship program where kids under 18 worked at the store without being paid in order to gain internship time, I suppose for their college entrance application or something like that, So the minors were minors, not minors, not coal miners, but minor children were working in this private business, okay, corporately owned, store, and this is a civil case. So what happens is and I don't know what happened with the criminal side of this, but a 13-year-old boy accused a non-tribal or non-Indian manager or something like that of the store molesting it. So we have certainly there's a criminal case there. We don't know how that worked out. But what he was doing was it was a tort case, a tort claim against Dollar General for damages and reparations for this crime, violent crime. And this is okay. Y'all remember the OJ trial? Are y'all young enough to remember or old enough to remember that? Okay, so what happened in the criminal case? The glove didn't fit, right? And the OJ Simpson trial, he was acquitted. He was acquitted in the criminal trial. And then the family of the family of Ron, what's his name? Anyway, the guy that was decapitated, basically, his family sued the O.J. Simpson estate, and they won that civil case. So you lose in the criminal trial. Well, even if O.J. Simpson would have been found guilty, there wasn't going to be any reparation or any repairs of some sort to the family of the victim. So O.J. Simpson was acquitted in this criminal case, but then he lost the civil case and basically lost everything that he owned. And so that's an example of what, when you have a criminal case, often a criminal case or a civil case will follow for damages of some sort. So that's what this, the tribe was going after, damages against Dollar General. And it was found, as Sarah said, using the second exception, the court ruled in favor of the tribe. The second exception was the tribe has jurisdiction. I shouldn't say the civil case won. The civil case was allowed to proceed because it was within the tribal courts. Okay, and that's what the Supreme Court or the circuit court was trying to decide, was whether or not this could even be heard if it was in the jurisdiction of the tribe, and it was found to be within the jurisdiction of the tribe. And the reason for that was because the second exception says tribes have an inherent interest in the safety and well-being of their people. Okay. Now this was the second, the Circuit Court of Appeals for the Second Circuit. I guess that's how you'd say that. It's the Circuit Court of Appeals for the Second Circuit, which was in Mississippi, somewhere in the South, I guess. And they don't have a lot of federal Indian law cases in that circuit. One of the justices or one of the judges in that circuit court wrote a very long and long-winded dissenting opinion. And did y'all have a chance to read that? I mean, most of the stuff that's in here for that case is the dissenting opinion of Jerry E. Smith. Jerry Smith is apparently not an expert in federal Indian law. Okay. Because, but he did, I mean, he's citing Oliphant all over it. But the thing he did notice that I thought was, maybe worth thinking about was that this judge is, he's citing for Dollar General, and what he says is that, how is Dollar General Corporation, it's incorporated in the United States. How is it supposed to understand procedure in a tribal judiciary, a tribal court of law? So he's kind of, it's sort of, it's like one of those really good questions from the student that never shows up to class, because they haven't read anything, but they're naive enough to ask good questions, so this guy is, he apparently doesn't know a lot, but he's asking the question, well, you have he's basically saying, you have these tribal courts. So how is a corporation supposed to, how is a lawyer supposed to have any idea of how to do discovery and to go through basic legal procedural stuff in order to pursue a case? Which I thought was a pretty good question, because they wouldn't, they wouldn't. The fact of the matter is, though, the tribes aren't that completely alien or different than state courts. They may have a few differences, but generally, they're not going to be that different.
Professor,
Yeah.
why can't you just have lawyers that specialize in it? You have lawyers that specialize in environmental issues and whatever else issues. So why couldn't you just have lawyers that specialize in tribal issues?
Well, you could, and I'm sure you do.
Oh.
That's probably an area where, because of the McGirt decision, you're probably going to have that growing now. It would be pretty interesting to see. You see Oklahoma. Let's see. University of Oklahoma School of Law and University of Tulsa School of Law both have Indian law specializations. They both have, tracks for specializing in federal Indian law. But it would be kind of interesting if they added like specialization in say Choctaw jurisprudence, or Chickasaw Nation law or something like that, which kind of makes sense. I mean, because those judiciaries, those 5 judiciaries, are now going to get a lot of business, probably, since they're now reservations, I would imagine. It's a good question. Maybe they should go. Maybe each of the nations should. I mean, some of them have their university affiliations. The Cherokee Nation has an OSU health center over in Tahlequah now. It is in Tahlequah, I think. But wouldn't it be cool for them to have their own law schools? Or at least be able to certify someone with not that they're that different, but anyway, yeah, I'm sure that makes sense. And probably there are a lot of attorneys in the state who understand how to operate within tribal systems. Back in 1993, probably before you were born, back in 1993, I got invited to a Cherokee Nation history conference, and back then Wilma Mankiller was principal chief, and but her the tribal solicitor was Chad Smith, who later was principal chief, and Chad Smith was basically he was the essentially the attorney general for the Cherokee Nation at that time. So he was, trained lawyer. But it makes sense. I mean, you've got these folks who come up within their own tribal legal system. They get law degrees from Northwestern or OU or someplace like that. So anyway, I'm rambling, and we're supposed to be doing a study session. Sorry. All right. So anyway, the point there is, it was kind of interesting, even though that Mississippi or whatever he was, Louisiana judge was kind of ignorant. Civil jurisdiction. Oh, here's one. What question about tribal civil jurisdiction, which was left open by Montana, did Nevada versus Hicks address? I'll say it again. What question about tribal civil jurisdiction, which was left open by Montana, did Nevada versus Hicks answer? You got to be reading real closely to catch this one. You look at page 404. Top of page 404. So Scalia was he was talking about the status of land and tribal civil jurisdiction. And what Scalia found was that the status of the land, rather than determining what standard to use, became one factor to consider when applying the Montana test. So Scalia was saying, okay, the status of the land, whether it's trust or Indian fee or non-Indian fee, that's something to consider when applying the Montana test. Okay. And what Roberts did was he went a step farther. And if you look at the opinion of what Roberts says, I can't remember where he says it. Oh, in Nevada versus Hicks, he quotes Scalia actually. He says, any direct harm to its political integrity, talking about the tribe, that the tribe sustains as a result of fee land sale is sustained at the point the land passes from Indian to non-Indian hands. It is at that point the tribe and its members lose the ability to use the land for their purposes. That's not exactly what I was wanting to read. What was it? Oh, it's actually on page 409. The author of your text brings it out. So, so Scalia said, well, it's something to consider, the status of the land. And what Roberts says is the status of the land was not merely a factor to be considered, but rather the dispositive factor. Now, you might have to look up dispositive. These Ivy Leaguers use these big words. And according to my handy dandy Webster Dictionary, dispositive means evidence, directed toward or affecting. Directed toward or affecting. So you have dispositive evidence or disposition. So it's, how would you interpret that? It's the dispositive factor. In other words, it's by far the most important factor. Okay. So John Roberts, Scalia, both very conservative justices. Scalia says, well, you need to consider the condition of the land. Roberts comes back later and says, no, the condition of the land is absolutely the main factor in jurisdiction. Okay. So Indian country makes all the difference. The type of Indian country makes all the difference. I think that's all of it. Oh, one last thing. Here's a true or false question. Somebody, y'all unmute yourself for just a minute. Okay. We got 2, 3. Come on, unmute, unmute. Hit that little microphone. You're good. Heath, you there? All right. All right. Well, anyway, here's the true false question. Just answer true or false. The Bill of Rights does not apply to Indian tribes.
What time period are we talking about?
2014. No.
I would say
Not that.
also it does.
Hang on a second.
That's now.
The correct date is 2008. 2008, and I'm referring to Plains Commerce Bank versus Long. The Bill of Rights, true or false, the Bill of Rights does not apply to Indian tribes.
True.
Got one true.
I'm going to say false.
Okay.
I'm going with false.
Okay. Falses are in. Good. We got 5 of you, so we're not going to. This is like a grand jury. I'm not going to have a tie. So far, we got 1 true and 2 falses. Come on, judges, where are you? Speak up. Well, unless you want to debate with Supreme Court Justice, Associate Justice John Roberts, no, Chief Justice John Roberts, sorry, Chief Justice John Roberts, unless you want to challenge his opinion, just read his concurring opinion in Plains Commerce Bank versus Long. Second paragraph, page 407. The Bill of Rights does not apply to Indian tribes. Okay. This is Chief Justice Supreme Court 2008. Now you said, yeah, or some people said no or false, and you said that probably because of the Indian Bill of Rights.
Right. The Civil Rights Act, Indian Civil Rights Act.
Indian Civil Rights Act. But what's the difference between the Indian Civil Rights Act and the Bill of Rights? The Indian Civil Rights Act applies to Indian tribes, but it's not the same thing as the Bill of Rights.
But what about citizen under the United States? Don't all citizens have?
Yeah, I come out with Jared.
We're talking about citizens, we're talking about tribes. We're not talking about individuals, we're talking about nations.
Oh, that's where the trick is. It's tribes and not individuals.
Well, I mean, you know, yeah, to a large degree, it's not really a trick. It never will apply to Indian tribes.
But, well, one's talking about tribal sovereignty, I think is what he's saying.
Well, the Indian Civil Rights Act, remember, was not about giving Indians or was not about bringing tribal members into the Bill of Rights. It was largely what it did was it required tribes to not violate civil rights that are covered under the Bill of Rights. So it was to police tribes. In that way, in that sense, the Indian Civil Rights Act, although it sounds real nice, was really kind of like PL 280, well, not PL 280, but it was basically the federal government getting into the tribal business and extending its, reducing tribal sovereignty, put it that way. Yeah, I know it's probably more cerebral than we need to get into, but yeah. Okay, so anyway, I just wanted you to see that. Chief Justice John Roberts just said that bluntly. Okay, let's move on. Do y'all need to take a break or anything? Grab a Diet Coke or something? Chapter 24, Indian Gaming Regulatory Act. I've got, let's see, 3, 8, 11, 14. I've got 24 points on this one. I'm not sure, I probably want to ask you all those questions, but I've got 24 points worth of questions here. So let's just get started here. Let's start with this question. Did the United States government encourage tribes to use gaming as an economic enhancement, a form of economic growth?
Yes.
True or false? Yeah. Okay. True. And here's that question I was referring to earlier. Why did California lose Cabazon? That's a 3-pointer. There are 3 reasons.
They were already participating in gaming.
Okay. They were hypocritical. So number one, California, the state of California was being hypocritical. Chapter 24. Got a lot of 3s in this chapter. Okay, so California was being hypocritical is one reason they lost. Another reason was what I just said, and that is that because of the trust doctrine, the federal government had previously encouraged tribes to provide to use gaming and other sovereignty-based activities, in which they have what we might call a economic advantage of some sort over states. Federal government had encouraged tribes to do things like bingo and gaming in order to become more financially self-sufficient. So federal government was backing the tribes to do this. California was hypocritical. And then there's one other reason California lost, and that was the tribe had an argument that it was so small that, and so resource poor that it really had no other form of serious economic development, other than something like a financial oriented entertainment of some sort, So, I mean, it didn't have enough land for, to become an agribusiness or something like that. But they did have a location where they could get tourist revenue. So those were the 3 primary reasons. I don't know if that question's that necessary. Here's a 5-pointer. How is the Indian Gaming Regulatory Act similar to PL 280? I'll let you think about that, and I'm going to get a Diet Coke. won't allow me to talk as much. Okay, so how is the Indian Gaming Regulatory Act similar to PL 280? For 5 points. Okay, what comes to mind with PL 280? What did PL 280 do?
Gave states jurisdiction over criminal matters in Indian Territory.
It extended what kind of jurisdiction?
What was that?
What type of jurisdiction?
Criminal jurisdiction.
Of
Indian,
what? Of the
Indian members oh yeah, of the state.
extended state criminal jurisdiction over Indian country. Where and where did that happen? That only happened in states that Congress specifically prescribed it to happen, right? Go back to Worcester versus Georgia, 1832. Worcester versus Georgia definitely said that states cannot interfere in the activities of tribes. They do not have jurisdiction in Indian country. States are without taxing ability, whatever. States do not have jurisdiction within Indian country, especially civil jurisdiction. But PL 280 expressly, because Congress said so, PL 280 extended state jurisdiction into Indian country. That only happens when Congress, it's only allowed when Congress intentionally does that. Okay. So in some ways, the Indian Gaming Regulatory Act is like PL 280 because, well, number one, it places limits on what tribes can do. All right. It places limits on what tribes can do, and it also brings states into the factor. Okay. What it basically does is said, okay, tribes, you can do gaming, but if you want to do casino gaming, class 3 gaming, then you have to negotiate with the states for what they will allow within their boundaries. To me, that's, and to a lot of people at the time, that was a huge infringement on tribal sovereignty, with regard to civil jurisdiction. Well, if the tribes aren't subject to civil jurisdiction or regulatory law of a state, why should they have to do that? Why should they have to answer to the states? States don't answer to them. So in that sense, a state jurisdiction and the sovereignty of the state was extended into Indian country. In some ways, you might just say, well, it's constitutional because Congress can do it. You can't fight Congress on it, but it just doesn't seem right. It doesn't seem right that the states should be able to get to have some leverage in allowing what tribes can do. Now, given that was in the 80s, right? And now we're about 30 some years later, 35 years basically, right? Where gaming is a different world, and so now it's the states, and some states too, like I told you about Connecticut, right? Connecticut, there was a state recognized tribe, and the state worked, I believe it was Mashantucket Pequots, they worked with them to have them get federal recognition, and because they got federal recognition, then they could become they could game under the Indian Gaming Regulatory Act. So it's like some states did their very best to make sure the tribes could do gaming, because maybe there's just one little tribe in the state. And Oklahoma is a different sort of deal, because we had 39 federally recognized tribes. Some are huge, like the Cherokees, and some are really small, like the I don't know, the Kaw Nation. Okay, little tiny Kaw Nation up on the Kansas border, or well, anyway, there are a lot of tiny tribes around. The Iowa down the street from me. So very limited space and very small number of personnel. They can't support huge gaming complexes. So anyway, but so in that sense, Indian Gaming Regulatory, like your textbook author says, Indian Gaming Regulatory Act was a federal law to regulate and really limit what tribes had been encouraged to do by the federal government. So here you got the Bureau of Indian Affairs for a good 10 years encouraging tribes to do bingo and to draw in tourism revenue and all this. Then you get a Supreme Court case in which California loses big. And because California is a PL 280 state, that means the non-PL 280 state tribes, they have even greater free reign, or they have even greater possibilities out there for them. So when the Cabazon band won their case, people in states like Oklahoma and Arizona and New Mexico, they're like, good deal, because the non-PL 280 tribes have a lot more independence and autonomy than those PL 280 state tribes. So of course, what happened was Congress reacted with the Indian Gaming Regulatory Act. Now, the difference with the Indian Gaming Regulatory Act and most other knee-jerk legislation that follow big landmark cases like this is in the Indian Gaming Regulatory Act, they started, they actually were getting into this in 1986 when all was coming ahead. But 86, 87, and 88, there was a fairly senior senator from Hawaii by the name of Daniel Inouye, and he was chairman of the Senate Committee on Indian Affairs, and he kind of led this. And he's Hawaiian, all right? So he's native Hawaiian, or was native Hawaiian, and so he kind of took this under his wing and shepherded it through, and was able to get a lot of input from tribes. And the result was that it was actually a long process, hearings and stuff, but the final product was pretty acceptable by the tribes. It wasn't perfect, but they weren't gonna fight it too much. And so the sort of the golden age of gaming got started in 1988, and it lasted a good 8 years. And that's when that was, the state of Oklahoma didn't have any sort of high stakes gaming, so, and it was quite against the development of Class 3 gaming in the state until much later. So the golden age of gaming lasted until 1996. Okay. Well, before we go there, here's a 3-point question that you would see. List and describe or define the 3 classes of games defined in the Indian Gaming Regulatory Act. What are they called? They're easy to remember, the names. Class 1, Class 2, Class 3, right? So what do those mean?
One's like for minimal value, traditional forms of gaming, Indian gaming. I think class 2 was like card games, but not. It doesn't include banking card games like blackjack
Right.
or electronic slot machines. And then class 3 was basically almost all forms of gaming that aren't class 1 or 2.
Well, Class 3 is everything, including Class 2.
I'm sorry, yeah, including.
Well, I mean, Class 3 is defined as everything beyond Class 2, but Class 2 is essentially, you're right, that's a good way to think of it, as non-banked games, where the game, if someone's playing the game, and Shayla, you can probably help us with this. What's the most lucrative form of gambling in the casino? What do people, what does the house win the most on? I think you're muted.
House wins the most on slots, don't they?
I don't know. Okay, we're having technical difficulties, but anyway, the house is going to win on these higher stakes games, and that's of course what. Well, okay, let's say that the non-banking games, basically people are playing for a prize, or they're playing for a set prize, or they're playing from revenue that's coming in from their ticket, or their entry fee, or something like that, or the cards that they buy. And then Class 3 gaming is what all the tribes really want. Okay, hey Shayla, thank you very much. Blackjack, poker, then gaming slots. Excellent, thanks. So we have these higher stakes games, of course, what the tribes wanted, because they're trying to raise revenue. They're trying to produce revenue so that they can operate their governments, so that they can fund different types of programs that they're not getting assistance, from the federal government. So they can build roads, so that they can build housing, that sort of thing. So a lot of different reasons, and but the Class 2 gaming was including high stakes bingo, and that's what Oklahoma had, and that's what all the states pretty much had legally. Class 3 gaming, on the other hand, well, okay, let's look at the requirements. Class 1 gaming is completely tribal. There is no outside supervision. The tribe has complete oversight of that. Class 2 gaming requires some supervision, doesn't it, by the NIGC, the National Indian Gaming Commission. Let's check this out, make sure I'm right. Class 2, Class 2, bingo or any other non-banked game in which the house does not hold a stake. It's only regulated by the tribe and the federal government through the Indian Gaming Regulatory Act. And I believe that is, I guess maybe it is or not, it doesn't really matter. And NIGC, National Indian Gaming Commission, was created by the Indian Gaming Regulatory Act. The Gaming Commission is just kind of an oversight committee. I think they report to Congress. But Class 3 gaming is everything.
it's the works, casino gambling, the high stakes stuff, the goal of all tribes. And it requires, well, it also, number one, it requires that the tribes poll their own citizens to make sure that, you know, this is something that people want to do, because not all tribes participate in gaming. I don't believe that. I don't think the Navajos do. I don't think they have. You know, Navajos are pretty conservative. They don't do a lot of the things that other tribes do. So they're not in on this. I think the Hopi might be. Not sure about it. I know the Pueblos are. Pueblos are into it. So you've got to have a tribal ordinance that allows it. And then what else? Class 3. The stipulations of the law come into effect. And basically the big one is you have to have supervision from the federal government, and you have to have a state and tribal compact. So you have to have basically a treaty between the tribe and the state. Okay. And the state can limit the type of gaming in individual games, because and only, let's see, the states can limit it to whatever the states allow themselves. So if the states don't have the equivalent of class 3 gaming, if they don't have a lottery, Powerball or whatever you call it, if they don't do that, then chances are they're not going to allow tribes to engage in it either. Okay. So why did I say the golden age of gaming ended in 1996? The golden age of gaming. $0.01 gaming slots are the big money maker? 1 cent? Like pennies? My goodness. That doesn't have much of a payoff, does it? I mean, you're just throwing pennies in, I guess. Throwing pennies in the fountain. So the answer to that question.
Would it have anything to do with Seminole versus Florida?
Absolutely. Seminole tribe versus Florida in 1996. So Seminole tribe of Florida versus Florida. And this was a Supreme Court. It went all the way to the Supreme Court. And as you need to read through the Indian Gaming Regulatory Act, because originally in the IGRA, the tribes were to negotiate directly with the governor's office. All right. The tribes would negotiate with the governor's office to develop a compact. And this governor of Florida, I remember his name. I remember the event because he kind of used it as a re-election campaign. Lawton Childs, Governor Lawton Childs. My sister lived in Florida anyway, and this guy, of course, okay, Florida's pretty conservative. It's quite varied, but overall, it's pretty conservative generally. You know, it's not like organized crime's not already in Florida, because it is. But basically, what
what the Indian Gaming Regulatory Act did originally was it gave states pretty much the power to approve the terms of the compact. But if the states, i.e. the governor, did not negotiate in good faith, then the tribes could sue the state in federal court. That was in the NAGPRA, and that was a big deal. States did not like that, and so Lawton Chiles kind of did the test case with Florida by refusing outright, by making it real obvious that he was not going to negotiate in good faith. He basically slammed the door on the tribes. And so, of course, that brought on a lawsuit. And that's what the states wanted, because they fought the lawsuit real successfully based on the 11th Amendment. Okay. The 11th Amendment to the Constitution. Let me go to my bookshelf real quick because I've got this. All right. Everybody needs one of these. Constitution of the United States with the Declaration of Independence. Has nothing to do with us. All right. So the 11th Amendment. I used to do Roman numerals so well, and now I get old. Okay. Amendment number 11. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. What is that? That was ratified in 1795, which at the time made a lot of sense because the United States was, a brand new federal republic. And okay, so the judicial power of the United States, federal government, shall not be construed to extend to any suit, federal court, I should say. Federal court will not extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. What's that mean? It's basically the sovereign immunity of the states, right? So what the states argued was that the Indian Gaming Regulatory Act was not only screwy for the tribes, it was really screwy for the states because it allowed the states to be sued by Indian tribes. It allowed the states, it basically took away sovereign immunity from the states and allowed them to be sued by tribes. And that's what Lawton Chiles was trying to do, and successfully won that case. And he made the argument that, look, in Worcester versus Georgia, states were not supposed to have any dealings with the tribes. We're separate. But yet the federal government has opened up the state's vulnerability, made them vulnerable to tribes. And so the ruling on it, the finding was that the 11th Amendment prevents congressional authorization of suits by private parties against unconsenting states. In other words, tribal sovereignty did not win against state sovereignty, at least states' sovereign immunity. Okay? So they had to amend Indian Gaming Regulatory Act in 1996. They had to amend it so that states could no longer be sued if they did not negotiate in good faith. All right. States that refused to negotiate in good faith couldn't be sued. So basically, the tribes couldn't do anything about it. But like I said, that was a long time ago. And the success of Indian gaming and the success of the expansion, the diffusion of gambling in general, it was no longer a monopoly of Las Vegas, of Nevada and New Jersey. It was no longer the monopoly of just two states. So gambling spread all over the place with lotteries and racing and so forth. And states would pretty much be fools to just absolutely tell tribes to take a hike when they wanted to negotiate a state tribal compact for gaming. Now, I don't know about Utah. I don't know if there are tribes in Utah that have negotiated state and tribal compacts. I'd be surprised if they were able to. I need to look into that. Maybe somebody would do a paper on that. That'd be cool. Kind of late for that, though. All right. The question here: what are the three requirements for Class 3 gaming? Three requirements for Class 3 gaming. Three requirements. You got to negotiate a compact. You got to be regulated by the National Indian Gaming Commission. And you have to have, the tribes have to have an ordinance within their tribe. Again, the federal government sets the terms for tribal sovereignty. The Congress sets the terms for tribes to act with sovereignty. A strange contradiction. All right. Any questions on that? Have casinos helped tribes? You can just nod up and down. Yeah, casinos have been fantastic revenue producers. Have casinos been successful among all tribes? No, not at all. Okay. Some tribes refuse to participate in gaming for whatever reason, cultural or whatever. Other tribes attempt to participate in gaming with very little potential because of their geography. I was trying to think of the Tonkawa tribe up near Tonkawa, town of Tonkawa. Really small reservation originally. Do you know what tribe, by the way, this is in Oklahoma, tribal geography trivia. What tribe occupied the Tonkawa reservation before the Tonkawa were removed to it? I will quiz no more forever. Yeah, I will quiz no more forever. That's your clue. Chief Joseph, right? I will fight no more forever. Was that his quote? Chief Joseph of the Nez Perce. The Nez Perce from up in Idaho, Washington. They were removed to Oklahoma, and they only stayed about 2 years, I think, before they went back. And then the Tonkawa were brought into their reservation. Anyway, they have very little geography, or very little. No. Wrong book. Anyway, the tribes are going to be benefiting by their geography when it comes to gaming, right? So if you if the in the area that tribes can establish gaming facilities on, those facilities must be on trust land. Doesn't have to be tribal trust land, I don't think. Could be private trust land, I guess, or individual trust land. But it has to be trust land, according to the Indian Gaming Regulatory Act. Right? But it's the spatial limitation to gaming facilities is limited to the historical boundary of the reservation. So for the 5 tribes, they can only establish gaming facilities within their historical boundaries. And I think I mentioned it before, but the census calls those tribal jurisdictional statistical areas, TJSAs. In Oklahoma, they're Oklahoma Indian or Oklahoma Tribal Statistical Areas, OTSAs, I think. I don't know why Oklahoma is different, but we have Oklahoma Tribal Statistical Areas. And basically, those are the boundaries of the former reservations, which now are not the former reservations in some cases. So, but if you look at the Tonkawa tribe, the amount of trust land within the former boundary of the Tonkawa tribe is going to be minuscule, right? But the Tonkawa can only build a casino within that former reservation of, not that many square miles, a few townships. So what if a and this wasn't brought up in your book, unfortunately, but it's really important. And that is, what if a tribe doesn't even have any trust land? The casino has to be built on trust land. Well, to ameliorate that, the Indian Gaming Regulatory Act had a provision that allowed the purchasing of land by the purchasing of land by the tribe, and a process in which to place that into federal trust. We've talked about that before. Not with the Oneida tribe. Remember that the Oneidas. This was before the Indian Gaming Regulatory. Was it? No, it wasn't. The Indian Gaming Regulatory Act was passed before that Oneida case, and the Oneidas in New York bought some land, and they said, well, this is our former reservation 200 years ago, so we're buying it up, and it's now tribal, it's now Indian country. And the state of, or the city of whatever town that was, said, no, sorry, we're going to tax you anyway. And they took it to court and they lost. And the reason was because the Indian Gaming Regulatory Act had created this process whereby tribes could acquire land, tribal land or individual land, and then they could place that into federal trust status. So if it's located within the historic boundaries of the reservation, it can be placed into federal trust status. Now, the federal trust status placement process is not as easy as you might think, because what's the federal government try to do? It tries to please everybody, all right? And when you try to please everybody, you really don't please anybody, but that's the way it usually works, and that's okay. The process of establishing gaming facilities was that was very strategic for tribes like Muskogee Creek Nation. Okay, and Muskogee Creek Nation's broad. It has interstates and major highways passing through it. It has a big urban area, Tulsa, some fairly large towns, and it's able to place those casinos strategically, almost always on the periphery or in a larger town. So casinos are placed on the periphery of the reservation, in the historical boundary of the reservation, and that requires placing land into federal trust if none can be found. If you're a small reservation like the Wichita, Caddo, Comanche, or Wichita, Caddo, and Shawnee down in Southwest, or the Tonkawa or something like that. If you're one of these smaller tribes, then you're really limited in terms of possible potential locations. So it's not such a great, it's not such a boon in terms of location. And in fact, Native American people are the most rural people in the United States as a group, or as a sort of a demographic. And to place a casino in the middle of a rural area where the only customers or the only patrons of the casino are going to be Native American people, that doesn't really do you much good, right? You have to bring in outsiders to spend their money. Otherwise, your casino is probably just not going to be even healthy for the community. Maybe you don't agree. I don't know. That was just something that struck me back in the 90s when this was all happening. Okay, I think we pretty much covered all of those questions. Okay. Any questions on the Indian Gaming Regulatory Act? Okay. We're doing all right, I think, in time here. I didn't really talk about the case in chapter 25 on cultural resources that involved NAGPRA. Well, first of all, what is NAGPRA? And why would you classify it within cultural resources? It's actually one of the main drivers of some of the tribal agencies now. Most all the tribal agencies have a tribal historic reservation office or a cultural resources office of some sort. And a lot of tribes have equipment, a particular instrument called ground penetrating radar, right? You've ever heard of ground penetrating radar? They used it in the Greenwood area to find these mass graves. And so basically it's a remote sensing type instrument, although it's not that remote, it's sort of a surface, it's sensitive, it's a sensor. And so anyway, it can locate graves. And what the Native American Grave Protection and Repatriation Act does is it hands responsibility and authority of Native American remains and cultural artifacts, material artifacts, to the tribe that is most closely affiliated with the site. And that's a very rough and dirty description of the law. But it came about in 1990, and it was brought about generally because of the preponderance of remains of Native American remains laying around in museum drawers. And I think I told you a little bit about the Natural History Museum up at Nebraska. Nebraska Natural History Museum, which is full of Native American bones. And, why is that even natural history? So it's sort of like, they grouped them with the saber-toothed cats and the mastodons and stuff like that, right? So basically native peoples and human beings remains were being treated like, objects in a museum or a zoo or something like that, which wasn't quite dignified. So this movement got started back in the 80s and was, it culminated in this, in the NAGPRA law of 1990. And from that's when a lot of museum curators started transferring a lot of these remains and artifacts back to the tribes. So, basically returning what was theirs. That was the idea. Well, the example of federal Indian law coming into play with that came in 1996. And so you get 6 years after the NAGPRA comes into effect, when everything's kind of happening because of NAGPRA. And you all know the story of this, the Kennewick Man? Heard of that? A little bit? So Kennewick Man is a skeleton or remains that were found by people at a lake in Kennewick, Washington. Washington State, again, is in the news in our class. And so I don't know if you read the story, but the story kind of went like this. These folks were, they were fishing and they found a skeleton, and I thought, oh my God, this is a really well preserved skeleton. It was so well preserved, they didn't realize it was ancient. They thought maybe it was a body that had been dropped in a lake, a few years back. And so they called the sheriff, and the sheriff came in and, they did a recovery of the remains, basically a forensic, collection of all the remains. And they started examining it, and they realized something's not right with this. And they brought in some forensic experts, and they said, this is a lot older than, historical stuff. And they wound up dating it to like 8,500 years old. And not only that, but the forensic specialist looking at the skull said, this skull doesn't even look like it's a Native American skull. And this is what, the news went berserk over this, because the forensic people said, this gentleman looks sort of like Captain Picard on Star Trek Next Generation. And, basically he was a very European looking skull. It was a long-headed skull, which doesn't make a lot of sense if it's a Native American skeleton. So of course everybody went berserk over this. And so the question was, wow, is this a European? Is this like a Viking or something, way before Vikings? Is this a European somehow that came into, because there's genetic evidence, since RNA has been being studied so closely, there's genetic evidence of European ancestry, European DNA in Native American, in Native American bodies. So, but like ancient stuff. And so this was, people were very interested in this. Well, what happened was that rather than, the scientists plopped this, took the skeleton, and a local tribe said, wait a minute, or local tribes said, wait a minute, this is Native American remains here. You can't just take it and start examining and all this. So it created a big lawsuit. The scientists filed a lawsuit against, tribe. The tribes had an injunction against it or something. So anyway, it was a court battle over a skeleton, a really old skeleton. The tribes claimed it as theirs, wanting to repatriate it, and that was like the last thing the scientists ever wanted, because they wanted to study this to figure out, and do DNA analysis and all that, figure out where this person came from, what it was, and all this. So it was tied up in court, but the scientists had possession of it. And so they went ahead and did what they wanted and mapped it all out and sampled it and then turned it over, and it was buried. It was buried with a ceremony and everything. Later on, about 10 or 15 years later, the evidence, once we started getting the human genome mapped, the evidence started pointing to not European, but, and your textbook didn't mention this, but rather than European, it pointed to Ainu. The individual was more than likely an Ainu. You know who the Ainu are? Sometimes referred to somewhat derogatively as the hairy Ainu. AINU. They're the indigenous people of Japan. And not only are they the indigenous people of Japan, they are Caucasoids. All right, they are Caucasian in appearance. So how that happened, I don't know. But if you look at the Ainu, you'll probably say, they don't look that Caucasian to me, which they don't really. But that's what the science. That's what the the anthropologists used to say. The Ainu are these indigenous peoples of Japan, basically on the island of Hokkaido up in the north. So they're it would kind of make sense that they would be traveling around the coast, maybe back during the last ice age, and maybe work their way down to Washington State. Maybe not such a big surprise there. Nevertheless, the law that was intended to, assist the recovery of Native American remains sort of, caused a lot of litigation about claiming remains. Okay, that's enough on that one. How about chapter 26, natural resources? Here are some questions for you. Well, first of all, know all the cases. And the main cases are Winters versus United States, 1908. Arizona versus California, 1963. And New Mexico versus Mescalero Apache tribe. I also told you a little bit about the Pyramid Lake Paiute and how they use their winter's rights up in Nevada, California, and it was Nevada. So anyway, be familiar with that. What do I want you to know? I want you to know as much as you possibly can about the Winters case and the interpretation of the Winters case and the development of what we call the Winters Doctrine. The Winters Doctrine. What are usually referred to as Winters' rights. So what kind of natural resources is this all about? This is all about water. Water law. Also want you to know, recall the two different types of water law that we have in the United States. The two different broad sort of antecedent systems of water regulation. Those are the English version, which we just call riparian rights, which really don't mean anything in our context here. And then the Spanish, or sort of the canon law version of water rights. The Spanish were coming out of Iberia, and they had water scarcity in Spain, and they had developed a system of water rights. In fact, I'm sure their system of water rights were also brought in from the Moors, from the Berber and Arabic-speaking peoples of North Africa, which occupied Spain for about 700 years, Muslims. So it probably has, there's probably Muslim influence in the Western United States. So, but the Spanish water law is referred to, or the Spanish system is referred to as a couple of different things. You can call it the prior appropriation system, the doctrine of prior appropriation, or just appropriative water rights. Appropriative or appropriation is the key word. Appropriation just means the first one to claim it has priority in time. Even if you're downstream from somebody, someone downstream from you or someone upstream from you may not have as much priority as you do, and therefore has to allow you the supply of water that you need, that you demand. Okay, so it's an interesting system that requires dates and requires a hierarchy, creates a hierarchy of rights. The oldest user has the highest priority. Okay. So the winner's doctrine, however, and generally appropriative rights have some rules to them. So the oldest claim is the priority. However, you must use the water or pass it on down the line. So you may have an old claim to the water but not use it, therefore you make sure that it continues to go on down through the system. That's the use it or lose it system. Use it or lose it. Now, in the winner's doctrine, however, you better remember how could you paraphrase the winner's doctrine? The winner's doctrine is basically like this. It's the finding by, a 1908 federal court case. Let's see, I need to go to chapter 26 here so I can see things. Strangely enough, in 1908, Justice Joseph McKenna, all right, we've heard of him before, very progressive fellow. Justice Joseph McKenna uses basically what he's sort of developing as the Indian canons of construction to interpret a treaty to interpret a water dispute on the Fort Belknap Indian Reservation up in Montana. And this involved the Milk River, and this is where the non-Indian settlers who came after the reservation was established started utilizing water out of the Milk River and diverting it into irrigation agriculture, basically depriving the tribe of its water resources. So what happened in this case was the tribe was found to have the rights to that water, and the primary reason they had the rights, basically they weren't using the water, okay, but they took a claim to it. And of course the agricultural, it was agribusiness back then. The agribusiness people said, look, why can't we use this water? Because they're not. And the Justice McKenna said the reason they have the rights to that water, even if they're not using it, is because they are on an Indian reservation. And that Indian reservation was created for one purpose, and that purpose was to be the permanent home and abiding place of that tribe. And because they're on a reservation, and it doesn't say anything about allotment, I don't think, because they're on a reservation, that implies that they are supposed to stay in one place and make a living off of the land. And since they're going to try to make a living off the land, they have to have water. If they're going to have agriculture, they have to have water. So we can't deprive that Indian reservation of water. In fact, no Indian reservation, due to its inherent, existence as a home and abiding place based on agriculture, and this is 1908, because of its, because it's a reservation, which implies agriculture, they have a right to the water that comes through their land. It can't be cut off from them. It's a natural resource that moves across space, but yet if it's crossing into an Indian reservation, the tribe has every right to use it. And not only that, they don't have to abide by the general appropriative system that says use it or lose it. The Indians can claim it and they don't even have to use it. So that's the main part of the Winters Doctrine. Anybody add to that? I missed something? Oh, there's also something referred to as the equal footing doctrine. Equal footing doctrine has to do with the requirement that states, or the ability of states to kind of control their natural resources. States have always been given over control over their natural resources within their boundaries, whether it's water, whether it's flying ducks, whether it's soil or oil and gas, it's coal. It's subject to state regulators. And the anyway, before we leave Winters Doctrine, Winters Doctrine then is 1908. And essentially the High Court handed tribes lots and lots of, recognized that tribes retain, catch myself here, tribes retained their rights to the water. They never gave those up. However, after 1908, strangely, 1909 is when Teddy Roosevelt left office, right? And we go into this period after 1908, 1909 in the United States where there is a huge push to exploit all forms of natural resources. And World War I comes along, and there's a buildup. And in the 19-teens, the United States goes full force in using and exploiting as many natural resources as it can to produce food and to produce war machines and that sort of thing. And during the 1930s, and especially in the 40s, 50s, and 60s and 70s, lots of the water in the West were dammed. I talked about that a little bit in class. The federal government spent, the equivalent of today's equivalent of billions and billions of dollars building dams and irrigation systems and basically subsidizing agribusiness big time. And the result was Indian tribes were never really given much consideration for water. So from 1908 to 1963 was a period when tribes had lots of water rights, but they were pretty much ignored. Tribes pretty much ignored on water rights. In 1963, however, a long bunch of litigation known as Arizona versus California, but involving a lot more than that, was concluded. And in Arizona versus California, 1963, we have some new things that come into effect with regard to Indian country. And that is, and that's not a Supreme Court. Yeah, it was a Supreme Court case. The opinion written by Justice Hugo Black, all right, 1963. And the primary product of that for Indian country was the creation of this theoretical measure, okay, called practicable irrigable acreage, PIA. In other words, the question was, if a tribe has access to the water, how much water can they possibly claim? And that was defined as, well, the amount of water that it would take to irrigate all of the arable land within the reservation. Okay, practicably irrigable acreage. Well, that was really just one step. I mean, that's discussed in your textbook, practicably irrigable acreage. But with other legislation after this, that amount of water was actually changed, because practicably irrigable acreage implies agriculture, right? Irrigated agriculture. But other questions came up like, well, okay, if what Justice McKenna said way back in 1908, that reservations were intended to be the home and abiding place of a tribal nation forever, then the federal government created those reservations for that purpose, and stated in the treaty that these reservations are, this is the abiding place of these people forever, as if they weren't going to leave. Well, that doesn't matter. It doesn't matter that most reservations are occupied by non-Indians, in most cases, or that most tribal members live off reservation. What mattered was what was in the law, what was in the agreement or the treaty or the executive order or whatever created the reservation, and that was a promise by the government that they had the rights to that water, and not only just agricultural rights, because if you're talking about the entire tribe forever and ever, the tribe's going to grow in population, right? And if your tribe's growing in population and is only limited to that amount of land, well, that's kind of limiting if you're just saying, well, this can just be for agriculture. So the amount of water that can be used is basically undefined. You can't limit that amount of water. Whatever the tribe wants, the tribe will get. So that's the way the water law works now. Tribes have an enormous amount of say in the amount of water that they want to utilize for whatever purpose. If they want to have some sort of food processing industry that uses a ton of water, then they're allowed to do that. They have the purview to do that. Well, it's about 8:29 almost here, so that's probably enough on natural resources. We got one chapter left, and that's no, 2 chapters left. That's religion. So I'll try to speed up here a little bit. For religion, be sure to know the context of 5 cases. Be familiar with what we discussed the other day about the First Amendment. That'll have been Monday, right? First Amendment, and you know, there are two. What are the two? I'll ask you. What are the two primary portions of the First Amendment when looking at First Amendment law? What are the 2 facets of the First Amendment that we usually examine? First Amendment is, it doesn't give you the right to free religion or free expression. It protects an existing right. Okay, that right existed before the Constitution. So where it comes from, I don't really know. Maybe it comes from God. But anyway, we've got this right, where it's a natural right of some sort. But all the Constitution does is it prevents the federal government from infringing on either what? Your free exercise of that religion or your free exercise of speech, whatever. It prevents the federal government from infringing on free exercise. That's one part. And it prevents the federal government from favoring any particular religion. Okay, and that's the non-establishment clause. So we have the free exercise clause of the First Amendment, and we have the non-establishment clause of the First Amendment. I guess I could read the First Amendment. Amendment number 1. Congress shall make no law respecting an establishment of religion. Okay, that's the establishment clause. Or prohibiting the free exercise thereof. That's the free exercise clause. And then we've got a semicolon, which then it goes into speech and press, and then another semicolon, it goes into peaceable assembly and petition, petitioning or redress of grievances. So the very first part of the 1-sentence First Amendment is about religion. You have the free, or you have the non-establishment clause, and you have the free exercise clause. I say the non-establishment clause, but some people would say the establishment clause. So no favoritism when it comes to religion, and no prohibitions when it comes to religion, right? Okay. So the questions of the cases involve Wilson versus Black, 1983. That's discussed length in your book. Another one that's not discussed much in your book, it's mentioned briefly, is Navajo Nation versus United States Forest Service. That's from 2007. Wilson versus Black is referred to as Snowbowl 1 because it involves a ski resort in the San Francisco Peaks, in Arizona mountains. A ski resort called the Snowbowl. I've never been there. But the Snowbowl was expanding back in the early 80s. And actually the Forest Service was planning to expand the ski resort on federal land. And it's not Indian land necessarily, but it's, well, it was, I guess it was in Navajo Nation. But anyway, the fact is that the Navajo considered and other tribes considered the site to be a sacred site. Okay. And expanding the ski resort would only further, reduce the sanctity of the site. And so it was like many sacred sites, it only appeared to be a sacred site once it was threatened, because most sacred sites aren't advertised. They're sacred. So anyway, the Wilson versus Block was a case in which the American Indian Religious Freedom Act was implemented, or at least attempted to be implemented, in order to protect this sacred site from unnecessary commercial development. Okay. And what did Wilson versus Block find? I guess that's probably one of the most important questions. What were the results of Wilson versus Block?
That AIRFA was a bunch of hot air.
You got it, right. The American Indian Religious Freedom Act, AIRFA, was mostly just hot AIRFA, okay? It was largely toothless. It's referred to as an act, but it was really just a joint resolution of Congress. It was a nice thing to do, didn't mean much, okay? So the American Indian Religious Freedom Act was pretty much just a policy statement. That is what the case brought out. There was no capacity in the law to enforce its policy, and so that was that. Snowball 2 refers to the Navajo Nation versus United States Forest Service, and that was later on, 2007. And in that case, the Snowball was utilizing artificial snow. They were blowing artificial snow. It's snow, I guess, man-made snow. Is that what you call it? Right. Anthropogenic snow. They were producing anthropogenic snow from treated sewage water, and the word got out, and Navajo Nation said, "Whoa, wait a minute! This is even worse. You're desecrating the sacred site. It's bad enough that you have a ski resort there, but now you're just covering it with poo." All right. And so anyway, I'm getting tired, so my language is getting bad. Sorry. Anyway, the idea was that the tribe's going to sue the Forest Service for doing this, so it makes a claim against it. And again, the American Indian Religious Freedom Act was touted, but again, it failed. It didn't do anything. The Forest Service basically told the Navajo Nation, "Your snow's just fine." Okay, and they lost the case. Next case is Ling versus Northwest Indian Cemetery Protective Association, 1988. It was in your textbook in length, but in this one, this involved some road construction in a national forest in Northwest California, and the road construction, or the new road, would have opened up an area that was utilized by 3 different tribes in Northern California as a sacred site. And so it directly threatened the sacred site. And the case came down to a matter of whether or not it was the government's job to look out for tribal religious practice. Okay. It really came down to whether or not it was the government's job to ensure that people within a tribe, a federally recognized Indian tribe, were able to practice their religion and of course, what the plaintiffs were arguing, or what this was with the Supreme Court. So initially, what the petitioners were arguing was the actions of the Forest Service, actions of the federal government, were preventing the free exercise of religion. And this was a really important case because not only for federal Indian law, but for just the free exercise clause in general. And what it came down to was that it led to something known as the what test. Not the what test. We got a bunch of tests in this chapter. Okay. So I want you to know those tests. And let's see here. Okay. Free exercise, right? Now, one way that people exercise is to dance. One way people exercise is to do country dancing. And there's a country dance called the two-step, all right? So free exercise, two-step. That's what we're using here. The free exercise two-step is a test in which the plaintiff who is saying that their free exercise is being limited, the plaintiff has to demonstrate that the government action or inaction places a substantial burden on the plaintiff's religious practices or beliefs. Okay. And if they are able to convince the court that there is an action or an inaction that is preventing free exercise of religion, then you move on to the next step. Okay, so one step, two step. And the second step is one in which the burden, whatever the government is doing or not doing, has whether or not the government has a compelling interest in doing or not doing whatever is inhibiting the free exercise of religion. Okay. And so if they both have equally compelling interests, or if both are legitimate, so that if the Indian tribe has a complaint and says, look, building this road is going to just completely eliminate our ability to do what we have done for 100 years, okay, or 1,000 years. And then the government has its point and it says, well, we need this road because this 6-mile stretch is going to is going to decrease fatalities between point A and point B. It's a safer route. We need this road. If both cases, both arguments are compelling, that means if they're both legitimate, not how legitimate, but if they're both legitimate. Okay, and I'm saying here they're both legitimate. If they're both legitimate, then the government wins. Okay, that's the way this works. The government interest will always prevail over a compelling interest of free exercise of religion. In other words, the will of the people or the good of the people of the United States or the good of whatever is always going to supersede the wants and needs of a religious group. Okay. So the free exercise two-step was utilized in Ling versus Northwest Indian Cemetery Protective Association. We talked a little bit about this Monday. Now, one thing that is recognized in your textbook to a good amount is that non-Western religions like Native American, all the various religious traditions of Native American groups may have a much greater connection to the land, to place, to site, to geography, than the traditional, what we might call the Abrahamic religions of Judaism, Christianity, and Islam. Those religions have their sacred sites, but Native American religions are very localized, very small in location, small in population. They don't have the flexibility that others do. So, building a road, a 6-mile stretch of road, could be the equivalent of bulldozing the Blue Mont, or that's blown up, bulldozing Jerusalem or something, or the Church of the Holy Sepulchre. Sepulchre? Sorry, how do I say that? Anyway, so it could be the equivalent, but that's the way First Amendment law operates. The government wins. So the free exercise two-step is one test. Another test that we discussed is the three-prong lemon test. Three-prong lemon test is refers to the establishment clause. So remember, free exercise two-step and the three-prong lemon test for establishment. And this is with regard to the case Access Fund versus Department of Agriculture. That was about the rock climbers at Cave Rock near Lake Tahoe and up in Northern California. And in this case, the three-prong lemon test requires all three prongs to exist or to be present for the government to be accused or be guilty of violating the Establishment Clause. Okay. So this is a test to see if the government has violated the Establishment Clause of the First Amendment. The three-prong lemon test. So the three prongs are, and this would be, of course, a great 3-point question. The three prongs are, does the action or inaction have no significant secular purpose? Does building that road have no significant secular purpose? Number 2, does building that road primarily push a religion? Or no, this is a different case. In this case, what it was sort of the opposite of the previous one. What was going on was the Forest Service. Anyway, the federal government was, what they did was they prohibited rock climbing on this sacred site.
they prohibited the rock climbers, and the rock climbers were suing them for access. They said, we want access because you've closed this to rock climbing because the Indian tribe said that we were desecrating it by climbing on it. And by favoring the Indian tribe, you're violating the Establishment Clause. Okay. So the test to see if there was establishment by banning rock climbing on this rock, does that action have any secular purpose? Does banning rock climbing primarily push a religion? Does it, in other words, does it promote a religion? Does banning rock climbing on this physical site excessively interweave agency policy with religion? And all three of those have to pass, and it's pretty easy for it to not pass. So it's really hard to get establishment cases, to win establishment cases. So and the easiest one for the government to be released from an establishment accusation is the secular purpose prong, because just about any excuse could be secular, you know. So the secular purpose, by banning rock climbing, the federal government could also say, well, by banning rock climbing, we're cutting down on the number of people who die at the site from falling. Okay, so it's a safety concern, or it's desecrating the physical beauty of the site. Okay, so, or it's damaging the site, which is a culturally important site. So secular purpose is easy to get and pretty much closes the case on the access fund rock climbers. Let's see what else here. I need to keep y'all so long. All right, Employment Division versus Smith, 1990. This is also called Smith number 2. It's about the Native American church and the use of peyote as a religious sacrament. It took place in Oregon, and if you remember the story, basically these two gentlemen who were Native Americans used peyote, but they also happened to be workers, people who were trying to help people get off of addictive drugs at a rehab center. They had a history of doing drugs themselves. They were supposedly clean, but then they took a drug test, and the drug test turned up peyote. So they were fired from their job, and being fired from their job prevented them from drawing unemployment. So they made the connection between their inability to draw unemployment and their ability to exercise their religion by taking of peyote, the sacrament of peyote. So this case went to the United States Supreme Court. It was a very important religious case. And it came down to Antonin Scalia wrote the concurring opinion on this. And basically the question of the case came down to, the reason it went to the Supreme Court, the question came down to a matter of whether or not a state law could, I'm losing it here. Back up for a second. This is a free exercise on an establishment. Yeah. Yeah, it was a test as to whether or not, because it was a religious sacrament, could Oregon rightly ban it? Okay. So could Oregon maintain its prohibition against peyote if peyote was being used as a religious sacrament? Was that an infraction of free exercise by the state of Oregon? I mean, was that an infringement of free exercise by the state of Oregon or not? And what it came down to, of course, you got to use the free exercise two-step, right? And the free exercise two-step hold on just a second. People are wondering where I am. Okay. So anyway, it was the free exercise two-step, of course, gave didn't allow the peyote users to prevail because basically the prerogative of the state was valid as well. Okay, and so the government wins. And the great analogy, I think it's one of the best analogies in the whole textbook, is in this one. It's like, okay, well, you know, if you practice the religion of the 15th century Aztecs, you know, where you sacrifice humans to, what do they do, to pacify the sun god, or to prevent Quetzalcoatl from coming back or something like that. If you need to practice human sacrifice, well, sorry, you can't do that in the United States because the government has a prohibition against human sacrifice or murder or anything like that. So that's a pretty good analogy. It kind of shows the point. In other words, you know, if you have, and the other side of that is most Christians probably wouldn't go for human sacrifice, so they're not going to be tolerant of that. So you're not only are you would that be allowing that would be creating an establishment infringement. You would be favoring a religion because other religions aren't going to like that. So the government has to stay out of the religion as much as possible. And it's just a good idea whenever you're visiting family and friends not to get on the subject of religion or politics or federal Indian law. Okay, well, maybe federal Indian law. The last chapter is about in chapter 28. It's really not very much. I'm going to ask you about why the Oklahoma Indian Welfare Act of 1936, also known as the Thomas Rogers Act, why is that somewhat, why does that have just a slight difference in why is that just slightly different from its corollary in the Indian Reorganization Act of 1934? So, and you might ask, I might ask you, why do we even have an Oklahoma Indian Welfare Act? Why were Oklahoma tribes exempted from the Indian Reorganization Act? But anybody want to express well, it had a lot to do with taxing and collecting taxes, especially collecting oil and gas taxes. And the Oklahoma delegation in Congress at the time, and at that time there were like, I think we had like 8 members of the House, some enormous number, like twice as many as we have now, and of course 2 senators. And so it was a pretty decent delegation. We were a rich state back then, and they were able to get Oklahoma exempted from the Indian Reorganization Act. I think because they were they're trying to figure out how best to prevent the federal government from taking over lucrative oil producing land in the state. And we also talked about Alaska. And so read that section on Alaska. Basically, what we say about Alaska is that Alaska has no Indian country. Alaska has a lot of Indian tribes, federally recognized Indian tribes. It doesn't have a huge federally recognized Indian population, but it has no Indian country because why? It has no treaties. And it has no treaties. So there was a problem back when oil and gas was being developed in Alaska in the 50s and the 60s. All these native peoples were going to have claims against oil and gas development, claims to forest and logging and fishing rights, whatever. But none of the tribes had been recognized by the federal government. None of the tribes had had land identified as theirs, as Aboriginal title land. So there was a dilemma. How do you deal with this? And the solution was the Alaska Native Claims Settlement Act, passed by the Nixon administration. And what this did was it created, rather than recognizing tribes as governments, recognized tribes as corporations. And so Alaska Native villages are actually called Alaska Native Village Corporations. And then those are organized into sort of super groups called Alaska Native Regional Corporations. And those corporations then receive a proportional share of royalties from natural resource development in Alaska, just like the state of Alaska receives tax revenue from things like gross production tax on oil. The tribes also receive a royalty from natural resource production. And not only that, they can invest it, and so they are able to operate their governments and actually do pretty well. Too bad we didn't have that plan back in the 1700s, late 1700s. But anyway, it's been judged to be a better alternative than reservations and recognizing tribes as nations, as governments, or whatever, rather than corporations, businesses. And it's 9:01, and I think I'll probably quit. All right, I will get this uploaded as soon as possible for you if you want to keep going over it. But otherwise, look for the exam sometime before noon tomorrow. All right, it's not posted yet, but I figure you might have time. You might need time to study or write papers or whatever.
I do have a quick question. Where are you posting the more recent videos?
I'm in the process at the moment. I've got them. I haven't uploaded them yet, but I've downloaded them from Zoom, and it won't take too long because they're not very big.
Okay.
I'll get that done before I go to bed. Okay.
Are we still doing?
Go ahead.
Go ahead, Jarrett.
I was just saying, sounds good.
Okay. Are we still doing we still have a couple quizzes left, right?
2 quizzes.
Okay.
Those soon too. All right. I might extend the semester for you if you don't mind. I don't ruin your weekend or something like that, but I'll try to give you as much possible time as I possibly can. All right.
Cool.
All right. Have a good evening.
Thanks, Dr. Bays.
See you later. Bye-bye.